Bob Gleaner of Robert A. Gleaner PC, real estate attorney here in New Jersey. I'm going to talk to you today what I tell my clients about security deposits. It's basically broken up into 5 different areas. The purpose of the security deposit, the maximum amount you can take, where it's going to be held, the proper use, and the release requirements. All right, let's talk about the purpose of the security deposit. The security deposit is to guarantee that the tenant is going to do what the tenant is required to do under the lease, and if they don't do it, there's money to be taken by the landlord if there's a default in the tenant requirements. For instance, if they don't pay their rent and they leave before the end of the lease, and there's a month of rent left that they have to pay, you can take that out of the security deposit. Suppose they damage the property, you can take the money out of the security deposit. We're going to talk about that a little bit more when we talk about use, but generally it's to guarantee the tenant's obligations under the lease. Number 2, let's talk about the maximum amount. It's 1.5 months of rent. 1.5 months. What that means is that if the rent is $1,000, you can take $1,500 as a security deposit. Or explained a little bit differently, if someone's moving in, you can take 1 month's rent plus 1.5 months rent of security deposit. So in that case, the example I gave, if the rent was $1,000 a month, you could take $2,500. $1,000 for the first month and $1,500, which is going to be the security deposit. Some people ask me, can I take more? No, it's a rule, it's a statute. 1.5 months is the maximum. Can I take less? Sure, you can take less, depending on where the property is and depending on the amount of the rent. Some people will only take a month. Some people will take less. As a matter of fact, you don't have to take any. I wouldn't recommend that, but there's no requirement that you take a security deposit. Let's talk about number 3. Where can it be held? It can be held in any banking institution that does business in New Jersey. There's some of these internet banks. They're okay. They have to be licensed to do business in New Jersey. That's the where. It also has to be an interest-bearing account. Not paying much interest on these accounts these days, but that's the rule. It has to be interest. The interest that accrues on that account is also the tenant's money. That gets us to number 2, in trust. You are holding a security deposit in trust for the tenant. You as the trustee is holding their money, and any money that's held plus the amount of the interest accrued belongs to the tenant. How are you going to open that account? You have to get them to sign a W-9. You can download this right off. Just type W-9 into a Google search engine. You'll get the request for taxpayer identification number. You put their name, you put the address of the property, and you have them put their social security number in there, and then you have them sign it. You're going to need that in order to be able to open the security deposit account in the bank that you choose. All right, now remember, because interest is accruing on the account, eventually, theoretically, it's going to go over the month and a half. And there is also a requirement that each year you have to return all interest accrued to the tenant. So you have to keep track of that on an annual basis. Any interest earned, even if it's only a few pennies, you have to issue a check to them and you have to credit it back to them, credit it back to the tenant. Weird requirement, but that's what the statute says. Sorry about that. Now let's talk about use. Now this is interesting because, as I referred to earlier, you can use it if the tenant does not meet the requirements of their lease, but you can't use it during that period of time while they're still a tenant. You have to wait until the end of the tenancy in order to be able to figure that out. Now, what do I mean by that? So let's say the lease ends on July 31st. You have 30 days to make a disposition letter, figuring out how much you're going to deduct from the security deposit, if any, and return it to the tenant, any amount that's not utilized. So theoretically, you walk through the property, they've paid their rent through the end of July, place looks pretty good, you're going to return the entire amount to them, you're going to send a check, and you have to make sure that you know where they're moving to so you can send that check. Now suppose you go through, they left it a mess, there's holes in the wall, their dog did a lot of damage to the door, and and they didn't even pay their last month's rent. You're going to have to send in a letter, dear tenant, your security deposit was X dollars, and up to the time of the end of your lease, it accrued X dollars in interest. Out of that amount, you didn't pay your rent, and I had to get a handyman to fix the door. I had to pay him $100 to do that, and there was a hole in the wall, and that was $150. So the balance is over and above the amount of your security deposit. You're not getting anything back. And you can even put in there, you owe me X dollars, send me a check. Good luck in trying to collect it. You might want to collect it. You could go to small claims court if you wanted to. That's a discussion for another day. But the point is, you have to get that disposition letter within 30 days of the end of the tenancy. And you can only use it after the tenant has left the premises. Now let's go to number 5. I kind of merged 4 and 5 when I was talking a couple minutes ago about the use of it. The release requirements, again, make sure you have the address of where they're moving to, so you can send that disposition letter and or send the check to them. If they do not leave you an address, if they sneak out in the middle of the night because they're not paying their rent or whatever, you may not have a forwarding address. Statute says you send it to the last known address. You know the last known address. It was where your property is. As long as you send the disposition letter to that location, you've met your requirement. If they ever decide to sue you later, at least you have the cover, you have the proof that you sent it to the last known address. It's very important. Make sure you do that within 30 days of the end of the tenancy. That doesn't mean 30 days of the end of the lease. If your lease was supposed to end on July 31st and they left on March 31st, you have to send it within that 30-day period of March after they've left the premises. So it's 30 days of the end of the tenancy, meaning if they abandon the property, or the end of the lease when they leave voluntarily or by agreement with the landlord. All right, quick review. Purpose: to guarantee the tenant's obligations under the lease. Maximum amount: 1.5 months maximum. 1.5 months times the monthly rent. Where is it held? Any banking institution that does business in New Jersey. 3, use: unpaid rent or damage to the property. Release requirements: within 30 days of the end of the tenancy, meaning when they end the tenancy, even if it's not at the end of their lease, or at the end of the lease if they leave voluntarily. Thanks for listening. I'm Rob Gleaner, real estate attorney here in Audubon, New Jersey. Be happy to talk to you about any landlord-tenant issues you may have, or any real estate issues you have. My office handles all types of real estate matters, including zoning and planning issues, residential and commercial real estate deals, and of course, landlord-tenant. Talk to you soon.